The ICC's expert review panel, of course, represents a lot of formidable and interesting things. It ranges from interests in strengthening the court to strengthening the overall international system and certainly promoting the fight against impunity. At first glance, it might seem as if it's proposing something that could be deemed comprehensive or comprehensive reform that might transform some of the structural problems that are part of the ICC's infrastructure. We know that tremendous amount of work certainly went into this process, a tremendous amount of collaborative work for sure. And the report takes on a range of internal considerations, operational, it looks at hiring issues, codes of conduct, social climate, and makes a whole host of recommendations. And so, yes, I can appreciate the amount of work that went into this project. However, while this report reflects these sets of internal processes and dynamics, upon closer examination, the report still falls short of some of the long-standing calls for reform and engagement. And this is an important point because there's a whole prehistory to this report. There were many sets of state-level dialogues that prefigured this type of review that involved ongoing calls for reform and rethinking. There have also been scholarly and civil society engagements, practitioner-based engagements, all highlighting the need for addressing structural limitations that are relevant to the International Court. For example, in 2010, African states called for ICC reform and laid out a range of concerns and three major amendments. Some of these concerns, and I'll mention a number of them. One of them had to do with the political act of giving the UN Security Council exclusive powers to make referrals and deferrals. So Article 13, the referral power of cases to the ICC, also the deferral of prosecution. That was Article 16 of the Rome Statute. And basically what we saw was that African states called for a rethinking of this systemic imbalance within which the court was situated. These were very real concerns and very real problems about the fiction of democracy, the unequal and political nature and double standards, of course, as well as questionable selectivity results. So that was one set of concerns that we saw in the amendments that aren't adequately addressed in the review. Another has to do with the call for the ASP to put in place prosecutorial discretion guidelines. So the development of guidelines for the prosecutor for the court and taking seriously the range of concerns that African states had around ensuring that there was a balance and limits to prosecutorial action. Another had to do with the fraught problem of prosecutorial selection and investigating two sides of a conflict. Over the past 8 years, we've seen tremendous issues around this problem in Côte d'Ivoire and a number of other places. Uganda maybe is also another place where addressing two sides of a conflict is critical, and doing so simultaneously, or at least in a context in which one side of a conflict doesn't feel as if they're being singled out, or that we think that it's fine for the prosecutor to pursue one case and then 10 years later pursue another case. That might be okay in legal time, but in terms of the politics of the everyday, it's not. And that was certainly part of the call for rethinking and reform that we saw coming from African states. A final point that I'll make in responding to your question is this point about the ICC's complementarity to regional courts and the call that African states, the call for reform that African states have made around Article 17. This is the principles of complementarity. where currently the language in the Rome Statute is one where the ICC recognizes the complementarity of national states, but not regional courts. This is language that needs to be reformed. It's not simply a matter, as we see in the report or the review, that African states have to understand the working of the court and that they're an appendage as part of a regional system to the court's work. But instead, what African states have been asking for is not just an amendment to the language where there's a recognition of the regional, so the national, the regional, but also that their forms of burden sharing or their ways that dealing with conflict and addressing questions of violence is also a collaborative effort where these African bodies are engaged in that regard. That's not necessarily the case. Instead, what we see in the review is the need to engage with international, interregional, and regional organizations. We see an identification of the African Union, the Organization of American States, the EU, etc. But the problem here is that the report, the goal of this collaboration is with the aim of helping relevant states to better understand the purpose and value of the court, and thereby building support for its activities. Now, if that's not a problem, I don't know what is. This says something about the nature of collaborative engagement with regions, that it's one-sided, that it's about these regional, the ways that regions can support the court, as opposed to the court also engaging dialogically with the needs of regions that are concerned with justice and approaches to justice in the case of Africa, on African terms, using African justice forms on African terms, which could involve legality, and it might also involve being aware of peace justice sequencing, a range of strategies that could be used in the context of violence. And so this is an important negotiation that needs to happen, and that making the amendment is one thing, and another involves ensuring that any kind of reform actually takes into consideration the dual nature of these relationships, regions with courts, and how burden sharing might happen. So overall, I guess I end with disappointment with the reform in this document, and think that there's a lot of work to do. There's a prehistory that needs to be addressed, and I don't necessarily see where the call by African states to reform are actually on the table in the report. So many of those questions still have to be addressed as far as I'm concerned at this stage.